Good morning. That's a short intro. Good morning, everybody. I'm Craig Aronoff, along with Barton Morris from the Cannabis Legal Group. We're here with our weekly Cannabis Business Live. It is, our pleasure to come to you here from Royal Oak, Michigan. We're going to be talking about a number of topics under Michigan's new Medical Marijuana Facility Licensing Act. And we encourage you to like us, share us, talk to us, engage us, ask questions. Certainly, we do our best to get back to you and make sure that we get all those questions answered. Please visit our webpage, cannabis-legal-group.com. We have some resources there for municipalities if you're interested in looking at locations. We are tracking that on our municipal page at /municipalities. And if you're interested in engaging in the industry but aren't thinking that you'd be an owner, we do have a jobs page. We're collecting resumes. And we're going to collect, marry talent to businesses as we move along this industry. Today, we're going to be talking about an update. Our Bureau of Medical Marijuana Regulation has had a lot of activity over the last week, and 2 weeks, really. And so what we want to do is just kind of bring everybody up to speed about a couple of bulletins that came out, as well as talk about some activities that both Barton and I have been involved in with the work groups that have been set up by our Marijuana Facility Licensing Board. So first, with respect to the bulletins, we had one that came out last week. Can you describe that for us a little bit?
On September 21st, the Bureau of Medical Marijuana Regulation had issued a bulletin, and these bulletins are designed to provide the industry, people that are prospective licensees and attorneys that are assisting them in advising us about the regulations and what the regulations are going to be. And because they've been given a very limited time in which to enact and adopt these regulations, they are providing us with a little bit of advanced information and effort and allowing us to plan, which is really helpful. In fact, I would say that the department has been really good so far as trying to keep us informed about what's going on. They have been in the public doing a lot of different advisory actions, telling us what's happening, and we appreciate that. So the advisory bulletin on the 21st talks about co-location of medical marijuana facilities. And specifically what that is referring to is multiple licenses existing in one location. For instance, it is often desired to have a grower also be located in the same facility as a processor, for obvious reasons, where the grower can then grow and cultivate the cannabis and then have it processed in the same location. And so what they have done is clarified the parameters by which that multiple licenses can be within the same location. And their brief advisory about it is actually very telling in many different ways.
Yeah, first and foremost, I think that the most important thing that I felt it said is in the second paragraph. It actually says a potential licensee may apply for and be granted a license to operate as a grower, processor, and or provisioning center. To me, on September 21st of this year, it was the very first time LARA actually said you can get two different licenses, and co-locate them on the same location. Those are questions we've often been asked for by clients. I think Barton and I, reading the tea leaves, talking to the licensing board, we had a very good indication that this was going to be acceptable, but we never saw it in writing in a bulletin advisory form until it came out in this bulletin last week. Now, this was the first step towards describing how you can do it, and really what it's saying is that they have to be in distinct and separate areas. So now we know there's got to be an entrance and an exit to each licensed portion of your facility. So if you have Unit A as your grow facility, Unit B as your processing facility, maybe even Unit C as your provisioning center inside the same structure, they're all going to have their own exits and entrances and their own security apparatuses. And how the flower transitions from one element to the next are the things that we're going to hear from the advisory board as far as it relates to transporting. Do we really have to put it on a truck on the north door out of the A unit to get it to the south door on the B unit? And those type of things I think we're going to kind of see round off the edges as LARA continues to provide us information about these type of situations. Another thing that's important, of course, is the municipality has to agree to allow you to stack those licenses. One thing we've seen is in some communities they say, quote, like there's 30 licenses for processing, 30 licenses for grows or whatnot. And if you have one of each, that's two of those. And so they'll be sitting on the same lot with two of them. So the municipality has to contemplate that maybe their inventory might be, they were looking at the amount of buildings it would hold, and that's why they came up with a number. And meanwhile, there might be more than one license in the same facility. And of course, they have to have licenses on the wall and those kind of distinct things as far as record keeping. So nothing really changes operationally. If you have that processing license, you're still going to be doing the same record keeping and transactional monitoring through the seed to sale tracking. But it'll be your system is side by side with your other license. Now that's a little different than the one that came out yesterday. And that,
I'd like to mention though one thing that I don't know if it's significant or not, but it says here I think it is significant, each licensed facility, right? So let's say I have a cultivation facility and a processing facility, right? And they have to be, and we want to co-locate them. With the same licensee, you're going to have both of these in the same facility. And then it says that each of these licensed entities have to have separate entrances and separate exits. It doesn't say that they can't connect to each other.
well, it does say that they have to remain distinct and separate within the different working areas. And
right, but it doesn't say, like, what if I have what if there's a door that separates between the two?
I think that that should be allowed. Now the question is can we allow a transporter to allow your flower to go from the grow through that door into the processing center? The statutory requirements of the transporter right now would indicate that they actually have to go on the truck out the door to the other side.
Right.
And so this kind of internal transfer that would hopefully be done more electronically, maybe with a manual audit, rather than physically having to give it to somebody to roll it on a cart through the door for you, which would indicate you're hiring a transporter to move it for yourself, but lose that chain of custody, which is what they're worried about. We don't see that rule yet. We don't know how that'll play out. And so if we just take it from the statutory language, it really means we got to send it outside the door and around to the other facility rather than through. And I think we all reasonably believe, and we don't know until the rules come out and maybe some statutory changes, that might be an onus that's not necessary on the industry. And so maybe hopefully with the work groups and some other commentary to the board, we can get some adjustments that say, there's an electronic way to do this. It's internal, it's easy to audit, it's manageable, it'll provide all the safeguards. Now that's different than to a provisioning center where it's actually hitting inventory for the consumer market. That one, it does make sense to actually have a third party sign off on that inventory. And so we'll see how those adjustments are made, but as it stands, if you're working in one side of the facility and you have a key pass that lets you to the other side, you should not have to go outside in the snow to get into the other side.
They've recognized that too, though. In the past, I've heard the director colleague Curtis talk about the fact that it may be absurd to have a secured transporter required to transfer from one licensee to another when they're in the same location. So I would think that they're going to address that she said that was something that they were thinking about, and perhaps it would require a legislative fix, meaning that it's going to require the legislature to pass a law that an amendment to the Facilities Licensing Act in order to remove that requirement that all transfers between licensees has to be done by a secure transportation company. Which, by the way, is, it's rumored to believe that there's a lot of people that actually lobbied very hard for that secure transportation licensee, and in that lobbying effort, they also required that all transfers be done through a secure transportation in order to ensure that licensee, it gets a lot of business. And so that begs the question, what strength or what power do these lobbyists and that have this interest of the secure transporter, what are they going to, or how are they going to influence the legislature with respect to the amendment that is necessary in order to fix it? Because I would imagine that they don't want that amendment. They want it to remain the way it is, and even if it's absurd, it doesn't matter. That still makes them more money, and you wonder if that had anything to do with the framing of this advisory bulletin.
Well, it might have, and certainly, just the bulletins themselves, and if we can just remind our audience and our clients and everyone watching that we have two different things that are competing with each other. One is the statute. And that's what we as lawyers look at as the law. That's the black and white.
Licensing Act.
Yep, and so that's the Medical Marijuana Facility Licensing Act, and that's the actual law as it exists. The rules that are coming out from LARA, these bulletins, are designed to help us understand how these laws will operate. And so the LARA is restricted by the limits of the law as to how far we can actually maneuver the rules. And I think there's a lot of, and certainly in discussing it just in general with the public, there's a lot of misunderstanding that LARA has the ability to just kind of unilaterally change some of these things. And that's not the case at all. What it needs to do is go back to the legislature, go through the amendment process to a statute, which is, it's got to go through certain, committees and get proposed and then get voted on and then make it to the floor, get voted on both sides of the House, and then eventually get signed by the governor. And so that process isn't something that's simply done. It takes some time, and we were, reminded of that recently by Representative Pete Lucido, who discussed that with us at the marijuana law section. That it's, making the sausage, so to speak, in Lansing takes some time and a lot of work. That being said, we're hopeful that there'll be some common threads to changes that would be made. Certainly, one of them is this use of how the supporter or the transporter will work inside a co-located facility. The next thing that LARA did, though, is, and this came out yesterday in yesterday's bulletin dated September 28th, they actually discussed what happens if you have multiple Class C licenses on a single facility, and they referred to it as stacking the licenses. And that one actually had a lot of different flavor to it than the original co-locating one. So why don't you tell us a little bit about a couple of the differences?
The Class C license is a 1,500 plant license, and so with respect to that license, the question is, well, how many licenses can you get, and can they be in the same facility? Because if they can, and what they have said yesterday is that they can, so a licensee, as long as they qualify, which is really important, they can get multiple licenses. So you get 2 Class C licenses. That means you can have 3,000 plants. And specifically, what they have said is that they don't have to be separate and distinct, which means that the licensee can have all of those plants in one location, which I think that would be absurd if they didn't do that. So that's exciting. I'm quite certain. I mean, this probably is some of the biggest news that has come out thus far with respect to their advisory opinions and their release of information about what the regulations are going to be like. Because, and it doesn't limit it at this point anyway to the number of Class C licenses that somebody can be an applicant for.
That's right.
So, I mean, I don't want to sound absurd, but what if somebody qualified for 10?
Yeah.
That gives somebody the ability to grow 15,000 plants. 15,000 plants,
yeah.
Right? So that's big, right? I mean, that really puts a whole new scope and understanding on what type of industry that this is going to create for Michigan. If somebody can have 15,000 plants or more, as long as they can qualify for it, and generally what the qualifications are going to be is, do you have enough money and the proper operation to be able to and building to be able to run it, and you're going to have the municipality license it as well. This is a whole new ballgame.
So let's break it down a little bit and just on those bare bones for a moment and kind of compare the 2 bulletins just real quickly. So last week they tell us you can co-locate. So if we were to talk 2 days ago about what that means for somebody who wants multiple Class C licenses without the new bulletin, what we would have been talking about is, let's say you have a 100,000 square foot building and you need 20,000 square feet to properly operate your 1,500 plant grow. Yes, you can do it differently, I know that, but just use this hypothetical, please. What we could have said is, well, you can get 5 Class C licenses stacked side by side, Unit A, Unit B, Unit C, D, and E, and each one will have their own entrances, and each
like
one
caregivers.
Just like a caregiver center would now that we see in some communities. But the co-locating one confirmed for us. So last week's bulletin confirmed for us that yes, you can have these 5 licenses in that 100,000 square foot building, but they all have to be separated out. And they all have to have separate management of their inventory and all of that. And quite frankly, last week's bulletin actually implied further that Unit A could be one group that has a license, and Unit B could be a separate ownership group that has a license. So they're co-locating on the same property. This bulletin yesterday said if you're the same licensee, because that's the distinction here, you have to be the same licensee, and you want multiple grows, Class C licenses in that 100,000 square foot building, you don't need any walls. You can put all 5 licensed plants side by side under a single lighting system, under a single utility cost system. So instead of separating it all out under a single security barrier, single waste management plan. So now what we've done is instead of aggregating the costs on these individual licenses in terms of each one being separate, they're all together now. And you have one large facility. Now plant 1 is going to be associated to license 1. Plant 1,501 will be associated with license 2. So in your seed to sale tracking, your plants will always be associated with a specific license that they're associated with. And so if you replace a plant out of the, let's say plant number 4,510, that's actually going to be your your 4th license. You know what I mean? And so that's all going to be tracked in your system. We don't want it to be like one system where all the plants are under that license. What this bulletin says is each license is going to manage their own plants within that same facility. But it can be done together. And the cost savings for the owner group that's got that license or those licenses is going to be significant. And so now those buildings can be used in a much different way than earlier anticipated. And so that's going to change the nature of somehow these larger grow facilities will play out. But by no means is that going to be something that prevents a smaller operator from coming in and doing their thing. I think that's the other part of this all. We're not discouraging that by any means.
I think that this has widespread ramifications in that it really allows for like unlimited potential. Because in Colorado they have large facilities like grow facilities. So they do in Oregon and Las Vegas as well, or Nevada. Facilities. I didn't think that Michigan was going to allow and start their program with something that could be considered a large facility. 10,000 plants is very. It's massive, right? And the production and I don't even know if anybody's going to be wanting to do that, but I'm certain that people are thinking about doing it, right? Because the amount of cannabis that is going to be created it's going to be a lot to be introduced into the market. It's going to be a significant expense in order to run that type of facility, especially startup. But I think what Craig said is important. Is that this doesn't change anything. If somebody wants to grow 500 plants or 200 plants or 100 plants even, they're still going to be able to do it. And as long as you have a robust business model, a business plan, operational strategy, then you're going to qualify as well. And if you're growing what the demand is requiring, then you're going to be successful.
Well, I couldn't concur with that anymore. And I think that, when we talk about the capital, again, going back to that, what will your business plan afford with the money you have? And staying within what you can afford to do. And keep your plan within that. So as ambitious as we might be, maybe you start with a building that's larger than what you need for your Class C license and eventually seek a second license down the line once you have the revenue and the money to do that. You don't have
once
to
you
do
get a
both at
license
once.
first, it's easier to get a license second because the state has already licensed you. That is going to go far with respect to your qualifications and obtaining a second license.
Yeah, absolutely. As long as you have the money to do it, I think they're going to be able to stamp that. Now, that allows us to kind of talk about some other things that we've learned kind of from the inside, having worked with these work groups that both Barton and I had the pleasure of working on. I was, part of the processor work group, which we met last Tuesday. Barton was on the safety compliance work group, and what that afforded us was the opportunity to meet with 18 other industry experts plus one member of the licensing board, along with staff from LARA. So we had their general counsel, Colleen Curtis, was there. Andrew Beersbo was actually the director, was actually at our meeting for a short time. I think he's kind of come in and out of all these meetings. We had Chris Hawkins from the Michigan State Police. He's one of the legislative attachés for the state police in the legislature. He was there as well as 2 other members of the LARA staff. And so what we were able to do is have a very robust, very encouraging conversation. I know my work group was led by Rick Johnson, the chairman of the MMFLA board. I think a lot of people going into the process may have thought that he had a negative view of medical marijuana. Quite frankly, coming out of that work group, I don't think so at all. I think I was very, very encouraged by his overall attitude and his willingness to work with it, his willingness to learn about it, and his general desire to just set this up correctly and not have a bias going into the process. And so whatever politics we may see in the past, I'm hopeful that will carry forward from our impression just in the room, and maybe the same will be true of the other board members. What was your thought on it?
I think, first of all, what you just said is fascinating, because Rick Johnson has had such a negative image as it relates to the being on the board and trying to perhaps stifle everything that's going on. I mean, in the industry and in the community, medical marijuana community, people are not liking him. So what you said, and I can relate, because I got the opportunity to sitting on my work group, I got the opportunity to get to know the board member from mine, which was Nicole Covert. She's a pharmacist by trade, and I'm going into it, I didn't know much about her, but having this opportunity, I mean, we worked together for 4 hours, and she was very engaged, and she was very intelligent. She brought in her experience from her background, and she talked about it, and she talked about what she thought was important. She listened really well. So I know what you're saying as far as like your ability to assess the board member. In this case, I had the ability to do the same thing. I was pleasant. I wasn't surprised. I didn't know what to expect, because I didn't know much about her. But now I feel like I do. She is definitely going to be a good advocate. She definitely has the right frame of mind with respect to crafting regulations that are going to be helpful to the industry. And she, in my opinion, seems to be very well qualified to be on the board. So I'm glad that you had the same experience.
Yeah, definitely. And you were mentioning her as a pharmacist and relating that experience to a safety compliance facility, which I think goes hand in hand. It makes sense to see why she fit there. Oddly enough, Rick Johnson, I didn't know that he had a dairy farm. I didn't know much about his past, but being a dairy farmer and looking at how that milk transitions into getting into yogurt, into butter, into other products, and into, of course, on the shelves at various outlets that sell milk. And the idea, and he very clearly said it up front, and any client who sat with me and we talked processing or the overall scheme will have heard me say something very similar, which was, if there's ever a recall in milk, we know the cow it came from. He's operated a facility that is a dairy farm that is following that exact kind of regulatory requirements, both in a processing element, which is what we're talking about for marijuana. The widget is the medical marijuana, not the milk, but the idea of how it's done is the same. And the regulatory scheme that actually allows the idea you can track it all the way back to the cow, even though it's been mixed with other milk and all the rest of it. And so, he was actually a very good fit for this conversation. Now, he might not have been up to date on all the equipment that's needed or the specifics of the process, but he was more than willing to learn and use by analogy all of his experience in talking about how we would infuse medical marijuana into butter, comparing that to how milk would be done, and how we can source it all back to the original cow versus the original farm where the plant comes from. And so our conversation framed around that kind of stuff, but the room itself was it was an engaging group of experts. And, while I feel very confident in what I do in my lane in this space, being at Cannabis Legal Group, it was really encouraging to see other experts who are side by side in their lanes. There were a couple other attorneys on our panel. There was food safety experts. So we had the idea of, what happens with medibles. So we had somebody who actually runs a candy factory, as well as other people that are food safety experts, a Bureau of Health expert. So an inspector from the city of Detroit was on that panel. But what was really interesting was the idea that this processing license isn't about just edibles or infusion, it's extraction. It's what's the process to turn the flower into something else? And here's 15 different ways you can do it. How do we regulate them all differently? And in the same vein, keep them consistent. And so it was
What'd
really...
you guys come up with?
Well, we just talked about how we need to break it down. And so we really need to break it down into slivers. So there's, of course, the extraction process, and, that creates the concentrates. And then there's, once you have the concentrate, how do you infuse that into other things? And so if we broke it down into the minutia, which is what the group started doing, it was a 4-hour meeting. And so anyone who thinks that we just all got together and high-fived and just baloneyed around, That was not the case at all. It was a
Yeah,
very
they had an
rigorous.
agenda.
It was an attentive
What were your agenda items?
Well, our agenda items was talking and breaking it down, like I was saying. So the first item is talking about the process, the machining, and the facilities themselves. The second process was talking about edibles and labeling and food safety requirements. And then the third part of it was just the overall general, recall requirements and the things that we would be worried about from the processing side and setting up a regulatory scheme around that. And so after we had some breakout sessions into some smaller groups, we all came back and we talked about just don't limit it to don't come in, from the onset and say butane's eliminated. No one's allowed to do that. Well, if you use a closed loop system and you're in a regulated, heavily, and we talked about how it's used in other industries and how in and of itself, you can't look at a house that blew up because somebody used, a cheap version of the system in an open loop and did it, with an irresponsible manner and compare that to what we're talking about for these multi-million-dollar built facilities. And so that recognition was something that we were able to do, is not say, well, let's limit the type of extraction. No, let's let all certified type of machining come into play here and allow innovation to dictate this, as long as, again, it can be, monitored and inspected and certified by third party. And I think that was a very important distinction, and we went on a little bit further from there. But why don't we talk a little bit about the safety compliance too and kind of compare how that looked towards the process.
We had 3 agenda items. The first was the standards by which that a compliance facility would pass would qualify for a license. And so there are, when we say safety compliance facility, I just want to clarify, what I'm talking about is cannabis testing laboratories. These laboratories test the cannabis for safety considerations, specifically microbiological contamination, pesticide contamination, or residual solvent levels, with respect, and also with potency and cannabinoid potency concentrations. And so that's called the safety compliance facility. And so one of the issues is what's going to qualify like a facility? What are those minimum acceptable standards? And so we had a great discussion about that. Next was talking about what types of things will we be testing for, and for instance, potency. Which cannabinoids will we be identifying for potency? CBD or CBG, THC, THCA, and so we have also broken into work groups about this particular topic. We had 3 different groups, and we got together at the end and had a really, really awesome discussion about it. But also microbiological contaminants and mycotoxins, heavy metals, residual solvents, pesticides. These are all really technical issues too. And let me tell you something. This group, I was really impressed. It was a very qualified group. There are many labs, lab representatives, people that work in labs right now that test for cannabis. Greg Mashad from the Michigan State, where he used to work at the Michigan State Police Forensic Science Division. It was actually pretty interesting because I used to do criminal defense and DUI law, and I used to battle with this lab all the time, and with Greg Mashad, and not battle with him. We were adversarial because he's with the Michigan State Police, and I'm always challenging his lab. And so now he's left there, and he's now perhaps getting into the medical marijuana industry, and I'm really happy to see it because he's a really smart guy. So, but there was other smart guys there too, and I was actually just happy I was the only lawyer there, which was I think appreciated because people like having a lawyer around to be able to answer questions. But I was happy just to be able to understand what everybody was talking about, because it can be a very complicated subject. Thankfully, I've got a lot of training experience with it, and so I was able to contribute quite a bit. I did a lot of preparation going into it, and others did as well. It was clear that everybody going into it wanted to be prepared and wanted to be helpful and useful. And what I found is that Andrew Briswell was there for a moment, for maybe the first 15 or 20 minutes, I think, and then he excused himself. But after that, Colleen Curtis and Nicole Culver and Jennifer Piggott, they and also Chris Hawkins was there. They were very interested in everything we had to say, and it was clear that we did have that expertise in the room to be able to provide quality and helpful information that is going to in the form of recommendations that are going to be brought back to the board. There's no doubt in my mind that what we had talked about is going to be included within the regulations. And to be a part of that was
great.
It was awesome. It was a long day, and at the end of it, I was like having to drive 2 hours back home because of traffic and stuff. But it was totally worth it, and it was fantastic. I thought they did a good job. Certainly. There could have been a lot more discussed as well. That was hopefully the first work group of many.
Yeah, and I would echo the last statements of the productivity of it and the preparation of the group and being prepared for it myself and all of that. And the work we put in was well worth it, and it was rewarding to be a part of that because, certainly it felt comfortable. It didn't feel out of place. It didn't feel, and all those type of things. And it felt like the right lane to be in as we talk about it. And you discussed how you guys broke down the facilities and stuff like that in terms of, what's needed. We did a lot of that too, but what's interesting in the processor license was the awareness that, are you going to be a kitchen? Are you going to be a vaporizing company? Are you going to be, a company that does topicals and actually uses some kind of other delivery systems that you have to incorporate the product into? There was some discussion, and this goes back to statutory changes in the processor group. There was the idea within the group that, some people were, who I think weren't reading the law itself, but were just generally assuming things, that, you can be a small bakery and just buy concentrates from another processor and then just be in the business of turning that into butter and making brownies or something, or cookies or whatnot. Unfortunately, the law says a processor is only able to sell to a provisioning center. So until that statutory change says that a processor can sell to a processor, in this particular rule set, we're talking about beginning to end processes. So it comes in as organic flour, it leaves as some whatever the product line that you're looking to do is. And so being able to infuse it in a cost-effective way is still something that the processing area is going to have to allow for if you're using, say, coconut oil on stovetops and everything for your bakery, as opposed to, tens of thousands of dollars for machining for some kind of hydrocarbon VHO extraction machine. But processing license incorporated all of this. And while we know it, until you're sitting in a room talking about the various elements of it and kind of trying to create a rule set that's going to be quite substantial because of all the differences, it was a very engaging thing. And I too agree that I hope it's not the first and only of these meetings. I hope they continue to respect and use the talent in this room to help formulate and shape the rules within each of these licenses. And my last comment is I did talk to a couple people who are on the GROW the GROW work group that met on Monday. And their takeaways are very similar to ours, in that it was very encouraging. A lot of expertise in the room, a lot of useful information. Everyone was prepared. A lot of industry experts. And so again, it seems like if we just look at the 3 licenses that we know more information about, I'm presuming the other 2 will follow suit. And of course, everybody's very interested in how the provisioning one will shake out with Mr. Bailey on that panel. So hopefully, and I truly keep the glass half full view of it, hopefully their takeaway is that, like mine with Mr. Johnson, with the speaker, that there's really more to this onion. And once you get down deep, they want to do it the right way. They want this to work. And as long as that's the real truth of it all, and we're going to set up rules and people are going to be able to operate, and Michigan is going to be a thriving market.
So to finish the show, there's a couple questions that are really asking about the same thing, which is how can smaller individuals be able to sustain themselves within the market? There's 3 different questions that we had that are fairly similar. A lot about caregivers, and so let's address that. There's something, we had a seminar last week about this, and when I had discussed this with our attendees. It seemed to be really popular. It was because it is going to be permissible for smaller individuals to be able to enter into and remain into the market. When I say smaller individuals, I mean people with smaller operations that have less capital. We're sitting here talking about people having 10,000 plant or 15,000 plant facilities, when and there's others that are going to have 200 plant facilities that are going to be able to thrive. And so with respect to caregivers, we want to remind people that program is not going away. So the caregiving program is going to remain in probably for a long time, because in order to get rid of it, the legislature would have to have a supermajority in order to remove it, because it was a ballot initiative, much like the regulated marijuana like alcohol initiative. And so that caregiver is not going away. And as far as their ability to continue to grow, which somebody had specifically asked about, that is not going to go away either. Specifically, somebody had said, can we elaborate on the impact of smaller and new folks wanting to get into the business?
Right. In essence, if you're a caregiver now, it doesn't change. Your patients will still be your patients if they're registered to you. You still have the same limit requirements. So if you have 5 patients, you can have up to 12 for each. If you yourself are a patient, you can have another 12 for yourself. So that structure remains the same. The question really will be is, what will the demand be for you as a caregiver going forward? Are your patients able to supplement their medicinal supply by going to provisioning centers? And if so, is it proper then to maybe tail back and curtail how much you're actually growing, so you can stay within the proper compliance for usable marijuana on site? And so just follow the rules if you're a caregiver, and that's going to be the key going forward. As far as smaller operators, there's no question that there's going to be room for that. There's people who own their land already. There's farmers that will use their existing greenhouses, and they're going to grow outside, and they're not going to need a lot of utility costs. So their upfront costs are minimal. They don't need all that extra money. What they need is the money to show that they can actually build the facility if they need any changes the way they need, and get to the finish line for revenue. And so, there's no limit or some kind of requirement from the state that we've seen in any kind of way or indication of it that looks at a specific capital requirement, because everybody's going to be a little different. And again, what your capital is for your business plan will dictate the success of your license application. And so, the smaller person has all the space in the world to grow within this industry. And as we look at the co-locating and the stacking bulletins, what that's really also saying is if you have a Class A license and you want to move from a 500 to 1,000, get a Class B license. You don't need to stack 2 Class A licenses. Doesn't make any sense. That's why they didn't mention it. But as you grow, as your business grows, keep trying to add your licenses. Keep trying to grow your, within it. So don't just spend all the money you make. Reinvest. And I think those will be things that we talk about with clients as we get towards this licensing period here. We're just shy of 3 months out until the application process begins. From my comments and talking with Chairman Johnson, it seems very clear this applications are going to begin December 15th. We know it. It's coming out. How quickly they get through it really seemed like, their discretion is if you check the boxes and everything matches up on your plan, there's no reason not to get a license. So I hope that remains true, and I think there's going to be a thriving market for the big players, the small players, and everybody in between.
Yeah, I totally agree. Don't think that smaller players are going to be squeezed out. That is not true. The smaller players just simply have to step up their game with respect to their business planning and respect to how are they going to fit within the market.
Right.
I mean, like a small grower can work with a small dispensary in a small town.
Sure.
A dispensary can source their material from anywhere they want, and especially if it's within a small town or within a small area, geographical area. People nobody's forced to deal with anybody. Just because somebody grows 15,000 plants doesn't mean that they're going to be supplying the entire market. In fact, the opposite could be true. Somebody growing that amount is probably not going to be able to do so at the level of quality that perhaps a smaller grower is going to be able to do it. So, and then with the dispensaries, there's going to be dispensaries with 15 stores, right? Like there's the companies with 15 stores. Then there's going to be dispensaries with 1 store, 1 license, and they're a small mom and pop operation. They're going to be able to and get their cannabis and their product from many different sources, including the small grower, maybe in the town next door. So don't forget that. And I hear a lot of people that are concerned about that, and that is not going to happen. As long as you preserve your ability to remain in the market even with the equipment that you're using now and the land and the building that you're using now, but all you got to do is just put together the qualifications that the state requires, and you will be able to continue and thrive in this market just like anybody else. Have
a marketing plan at the end of the day. And I spoke with a supervisor in a town taking applications the other day, and that was part of the commentary and advice that he was giving back was, of course, how are you selling your product? Where's your market? Know it up front. Talk about it up front. If it means you have 2 salespeople driving around the state or whatever it is that you're doing, make sure it's all predicated and set up in your plan. You can't just assume because you grew it, somebody bought it. There's also going to be contracts from processors to growers to have a specific number of plants allocated. So these processors who are looking for small growers to take 50 or 100 plants a month or whatever they are. And so there's lots of different interaction bilateral contracts we're going to see that we'll be working on for smaller players, for bigger players, and again, it's just a really exciting time. We are very encouraged by what we've seen this week, and we're encouraged for our clients, we're encouraged for the community, and we're encouraged for the state of Michigan and where their new medical marijuana market will go. And from our purposes, we look forward to discussing this again next week. So for Craig Aronoff and Barton Morris, thank you for joining us. We'll see you next week. Have a great